what's the myth with class actions? Like, do you have to be the first person to bring a class action? Or if there's a class action already existing, do you just jump on that? I mean, at what point would somebody contact you for a class action?
So if anybody thinks that they have a viable case, my suggestion is they should talk to an attorney, whether it's me, you, or somebody else. They should talk to an attorney as soon as possible just to make sure the statute of limitations doesn't run. But as far as multiple class actions go, you can have more than one case filed against the same defendant as a class action. But a lot of times what happens is the court consolidates all of these class actions into one class action, and all of them are fought at the same time, and it's one trial for every case.
Welcome, ladies and gentlemen, to the Modern Lawyers Podcast. I'll be your host, your lawyer Ali, and I'm with attorney Rod Bidgoli. How are you?
Good, thank you. Thanks for having me.
Absolutely. So I know a lot of people, and I have to say, Rod is one of the smartest people that I even know. No, true story. Rod, can you tell us a little bit about yourself?
Sure. I've been a civil trial lawyer for close to 25 years, and I've done defense work, I've done plaintiff's work, I've done a lot of different types of law. I started out as a securities attorney back in the 90s.
What is that?
So securities has to do with corporate law and corporate securities like stocks, bonds, things like that. Those are called securities, investments basically. Mm-hmm. So I started when I was in law school. I was working for a securities broker dealer, like a stock brokerage house, and I was working as the assistant to the general counsel. And then once I graduated from law school, I went and worked for another broker dealer as their general counsel, as their in-house counsel. So I was the company's attorney, and I did their litigation around the country, and I did a lot of transactional work for them and the SEC, Securities and Exchange Commission stuff, and FINRA arbitrations, all kinds of stuff. So I was doing a lot of defense work back then. And then in early 2000s, when the company moved to Texas, the headquarters was in Texas. I didn't want to move to Texas. I like California, so I decided to stay here, and I just went out on my own. I started my own practice, and about a year later, my old partner and I started Razavi Law Group, and I was a partner at Razavi Law Group until last year, and then starting this year, I have my own firm again.
Good for you.
Thank you.
That's amazing. Regarding the security side of it, I know like right now stocks are hot. They've been hot. Right now the market's down, but Elon Musk, Dogecoin, GameStop, do you come in when there's like insider trading? I mean, when do you come in for that?
So a lot of my experience has been going after banks and after stock brokerage houses for providing bad advice to clients. So when a client typically, it's not for the people that go on E-Trade and do self-trading. Mm-hmm. It's mostly, although there are cases like that, my experience has been going after the Merrill Lynch's of the world and the Payne Webbers and the U.S. banks and all the big names like that. So if they provided any kind of advice to an investor and it turned out to be bad advice, I went after them.
I mean, do you go after the big boys?
I have. They know me by first name.
And you mentioned you've done plaintiff and defense side. What is that? How does that work?
Yeah, so over the years I've done a lot of both sides of the table. Like I said, I started as defense counsel, as in-house counsel, and I did a lot of defense work. The company was being sued. We had offices in 42 different states, so I was busy traveling to all these different states and defending the company. We had offices in Florida, New York, California, Texas, Nebraska. So I was all over the place with litigation and with arbitrations. When I went out on my own, I did a lot of plaintiffs' work, so I represented the individuals against the big banks and the stock brokerage houses. So that was that side of my practice. But then over the years, I've done other types of law as well, including employment, which is a big part of my practice. I've done both plaintiffs' employment cases, suing companies on behalf of employees, and I've represented employers and defended them against their employees. So work both sides.
Gotcha. And I think against all popular belief, you are a lawyer that's good with numbers.
I am. So my background was in engineering. I got a degree in mechanical engineering before I went to law school, and so I had to be good with numbers. And then when I started working in the securities field, I was doing a lot of number crunching. So, and that's helped me with both the securities side and the employment, because I do a lot of wage and hour litigation, and it's a lot of numbers.
Gotcha. And some class actions?
I do. I've done several class actions at my old firm. I did a couple of class actions. We had a class action against Ford Motor for defective brakes. I had a class action, or I should say, we had a class action. It was kind of a complicated class action. It was against, it was the Cosmopolitan in Vegas, and they had sold some properties, and there was a class action against them. And then we came in and we ended up suing the attorneys that brought that class action against Cosmopolitan. So it was a complicated case. I'm just boiling it down. But yes, and currently I've got a class action going on against a security company that provided security services to Apple and Dave & Buster's and a lot of big companies. So we're going after them in a class action lawsuit. It's a wage and hour case.
Good for you. Watch out for Rod, everyone. What's the myth with class actions? Like, do you have to be the first person to bring a class action? Or if there's a class action already existing, do you just jump on that? I mean, at what point would somebody contact you for a class action?
So if anybody thinks that they have a viable case, my suggestion is they should talk to an attorney, whether it's me, you, or somebody else. They should talk to an attorney as soon as possible, just to make sure the statute of limitations doesn't run. But as far as multiple class actions go, you can have more than one case filed against the same defendant as a class action. But a lot of times what happens is the court consolidates all of these class actions into one class action, and all of them are fought at the same time, and it's one trial for every case.
I see. Wow. One trial for every case. Okay. And given the fact that you've been doing this for 25 years, you've seen the good, the bad, and the ugly of law so far. What phase of it are we in right now, and has it changed?
It's evolving. It's always evolving. I don't know about good or bad, but it's always evolving. Like I do in my wage and hour employment cases, I do a type of lawsuit called a PAGA case, which in California, it's a specific law to California. It stands for Private Attorneys General Act, and what it is it's similar to a class action lawsuit, but it's not a class action lawsuit. So you, as an employee, you can bring a case on behalf of the state of California and enforce the employment laws of the state against that employer. And this law is from 2004, so it's been about 18 years now. And there has been a lot of case law at the state level. And a recent case, Viking River Cruises, was decided by the U.S. Supreme Court, which kind of changed the landscape of PAGA. So there's always things like this happening in law, and new case law coming down that changes everything. So Depends on what side of the coin you're on. You might like it, you might hate it.
Gotcha. And when there's new case law, I mean, do you just get an email that says new case law, or is it something that you're a forever student? I mean, how does it work?
There's a reason it's called the practice of law. We practice a lot. So case law, I mean, it's like drinking water out of a 10-foot wide pipe. It's just impossible to keep up with every single case. I do get case law emailed to me on a daily basis, but that's just a small fraction of the cases that come down the pike every day. So as an attorney, as I'm sure you do the same thing, we have to research cases, and there are research tools. Thankfully now it's all computerized. Back
Sure.
in my day, everything was in a book. So we have to look up case law and see what the latest case is on a specific subject.
I see. This is just from my own experience. I've seen that a lot of lawyers now, they specialize. They specialize in one field. And, when you're an attorney, I just feel like you know so much about so many different types of law. And there's not many lawyers that know how to do that anymore because they just do one thing. And I mean, if they're a personal injury lawyer, they just do rear-end car accidents. They don't even do all the types of personal injury. Yeah. Do you think it's changed for the better or for the worse? Because, when I talk to, my dad's more old school, and he's like, you should do all these types of law. And I'm like, I don't know if that's how it works anymore. But when I talk to you, you know so much about every type of law. There's not many attorneys that I know like you anymore. So
Yeah.
What do you think about that?
My personal opinion is everybody should specialize in their area of law. Not too many people do it like 50 years ago, that it was like any kind of law that you do. It's called pedestrian law, anything that walks in the door. So, I think people should specialize. I kind of specialize myself in the securities, and even in the securities field, it's specialized.
Mm-hmm.
You were asking me earlier about class actions and insider trading, things like that. Honestly, I don't do a lot of that stuff. I mostly do only cases against the advisors and brokers.
Mm-hmm.
So, yeah, there are attorneys that do a lot more, but I like to be specialized. Even in the employment law that I do, I try to concentrate my practice on wage and hour issues mostly. It just gives me the know-how to do a good job for the clients.
I see. Yeah. Do you think that there's more law now, and that's why people need to specialize? There's just more case law, and as you said, it's like a lot of water in a pipe, and there's no way you can take in all the cases and law and things like that.
Absolutely. I mean, there's so many new cases coming down the pike. There are new statutes coming down all the time. So yeah, there's just a lot of new law.
Okay. There's a hot topic that I want to pick your brain. Traditionally, only a lawyer and a lawyer can own a law firm together, or only a lawyer and a lawyer can fee split on a case. So if a lawyer refers another lawyer a case, legally that referring attorney can get a referral fee. But if my neighbor that's not a lawyer refers me somebody that they know, generally you cannot give a referral fee or anything of substance to them. But it seems like the laws are changing. Arizona's changing. Non-lawyers can own a law firm in Arizona, and maybe that's going to pass in California. What's your thoughts on that?
Yeah, Arizona is one of the first states that's allowing this. California has always been, let's wait and see what happens to the other states before they decide if they want to do it. So I think it's going to be a while before it happens in California. Whether it's a good thing or a bad thing, I don't know. We'll have to see what happens in Arizona and some other states. But it's an interesting conundrum because it's freedom to conduct business. So I would like to bring a partner in. And over the years, I've had people say, hey, I want to invest in your law practice. I want to become your partner. And I tell them, if you're not an attorney, I can't do that. Sorry.
Yeah.
So would I like that? I think it would open up my hands as an attorney if I have investors, just like any other business, and they come in, they put up money, and they share the profits with me. But I can't do that, so I don't. Now, would it be a good thing? Potentially. I mean, for attorneys, it can be a good thing. For the general public, it can be a good thing. You know, they can own part of a law firm without being an attorney. The reason this has been a no-no over the years has been because they don't want an investor to come in and tell the lawyer how to run his business and get access to confidential information of an attorney. So, and I'm sure there are going to be a lot of regulations coming down the pipe for all that stuff.
I see. Do you think, like, you know, the Google law firm or like these big companies are going to come and take over?
They can.
Yeah.
You know, if they want to invest, I'm sure they can, and they will. But who knows? I mean, Amazon is notorious for doing things like this. Costco, I know. I was in talks with Costco quite a few years ago, about doing something similar to this. They wanted to provide incorporation services to their customers, and they talked to my firm about providing those services to their customers, but didn't work out. But yeah, I mean, they can end up owning a piece of a law firm or start their own law firm, hire attorneys to work for them.
Sure. You know, I know some of the younger attorneys, they feel like they're going to get replaced. Is there any advice you'd give them, any skill set they should pick up that, you know, Amazon and Google can't just come in and take over the field of law? They have a skill set that is indispensable. And what would that skill set be?
It's hard to replace attorneys. I mean, even if a big company comes and starts a law firm, they still need attorneys to work for them. So they're still going to need attorneys. That's not going to change. The best thing an attorney can do, a young attorney, is really learn how to practice law properly. If you do that, you're always going to be in demand. You know, when I started, my bar number is in the ones. Now we're up to the threes. 300,000 some odd attorneys now. Probably the first, and I'm going to upset some older attorneys here, the first 50,000 or so have probably either died or retired. But, you know, we're talking about close to 300,000 attorneys right now. When I became an attorney in 98, it was close to 200,000.
Wow.
So at 150,000 new attorneys, I don't even know what the bar numbers are up to now,
Sure.
but about 150,000 attorneys just in the past 25 years. So, but with all of that, there's still a shortage of good attorneys out there. You know, I have friends in other law firms that are always looking for good attorneys, and they're hard to find.
Yeah. Yeah, I hear you on that. And ladies and gentlemen, you know, most people probably can't afford Rod's hourly rate, and he's been kind enough to start this Q&A with us, where he'll take questions from the audience, and he's going to give his free thoughts. Don't use it against him. Disclaimer, it's not legal advice. There's no attorney-client privilege. But before I get into that, there's one thing that I want to know. I'm a personal injury lawyer, and since I've become a personal injury lawyer, there's been a cloud over my head that there's going to be self-automated cars, and there's not going to be car accidents, and you're going to be out of business living on the street. What's your thoughts on that? Is it happening? Is it happening sooner than we think? I mean, should personal injury lawyers start looking into different fields of law?
Self-driving cars, they are here. You know, I think it's going to be a couple of years before they really take off. Like Tesla, I know they've got the whole self-driving thing, but it's not door to door. You know, sit in the back seat. You still need a driver behind the wheel. So I think it's going to be a few years before that happens. Quite a few years. But even then, you're looking at maintenance of the cars. You're looking at problems with the tires. You know, a self-driving car is not going to tell you if the tire thread is low. And if that tire thread is too low, it blows up and causes injuries. Guess what? The owner of that vehicle is going to be responsible. So you're going to be in business for a while.
I appreciate that. Question number 1, and I'm going to keep it anonymous. So it says, I'm currently renting my apartment and I want to go traveling for 2 months. Can I have a friend live in there and pay rent while I'm gone?
So that's a landlord-tenant issue. So with landlord-tenant issues, a lot of times it comes down to what the lease agreement is between the landlord and the tenant. If the lease agreement does allow the tenant to sublease or assign the lease, then yes. But a lot of lease agreements do not allow subleasing or assigning. An assignment means, let me back up. A sublease means you're the tenant, and like in this situation that the person was asking, they're still going to be the tenant, and they want to sublease their premises in the entirety or a piece of it to me. So you can say, Rod, I'm paying $1,000 a month, and I know in California nobody's paying that rent, but I'm paying $1,000 a month in rent, and why don't you take over this space for 2 months for $800 a month, or $1,200 a month? It doesn't matter. That becomes a sublease. An assignment means that you turn over the entirety of the lease to me, and I take over that lease, and I become the main tenant. So whether it's a sublease or an assignment, either way, the landlord typically has to agree to it. If they don't allow it, and most leases that I've seen don't allow either an assignment or a sublease without the approval of the landlord, then they can't do it.
I see. So is it prudent to contact your landlord and just not do this on your own?
Absolutely. Talk to the landlord, and in this case it's residential and commercial. It's a little bit different, but it's always good to have a conversation with the landlord and try to get their approval. Most landlords just want their rent, and they'll say yes, but they want to make sure that they pre-approved you're in there, and they don't want to have a serial killer come in and take your place. So talk to them and get their approval first.
Sure. And to take it one step further, if the landlord does allow you to sublease, I guess, if they allow you to sublease and that subletter does something bad or wrong, are you going to be on the hook for it too?
Typically, yeah, that's a very good question. So typically, if it's a sublease, the master tenant or the master lessee is on the hook. So if the tenant comes in and burns the place down, they're on the hook, but so are you as the tenant, as the main tenant. So make sure if you're going to sublease to somebody, it's somebody you trust, and make sure insurance is in place and you're protected.
So no X's, nothing like that, everyone. All right. Question number 2. When interest rates were low, good old days. When interest rates were low, I bought a house and I've been having parties. My neighbors keep calling the cops on me. I thought I can do whatever I want on my private property. What are my rights?
So, yes, you do have rights on your own property. If you own property, you can do whatever you want on it, with some limitations. The limitations are, if you are part of a city, you have to follow the city rules and regulations and laws and ordinances. If you're part of an HOA, a homeowners association, you have to follow their rules, and they can have very strict rules about noise and loud music and things like that. So not knowing where this person lives, if he or she lives in an HOA, a city, where I live, we don't even have a city. We're part of an unincorporated part of the county, so there are no city rules. But the sheriff can still come knock on my door and say, hey, your music is too loud and you're bothering your neighbors. And if they come out a couple of times and we still do it, they can still arrest me. So you can do what you want on your property, but there are limitations. Yes.
Sure. Is it called being a nuisance? Is that?
That's one of the terms. Yeah. If it's loud music, if it's smell, or if it creates some kind of a discomfort to the neighbors, that can be called nuisance, and they can sue you for that. Actually, there are different types of nuisance: public nuisance, private nuisance. So it gets complicated, but yes, that could be a nuisance potentially.
Sure. So if I'm understanding correctly, your enjoyment shouldn't get in the way of your neighbor's enjoyment. Would that be a good way to do it?
Very, very well put.
Okay, fair enough. And final question that we have. During COVID, my friend borrowed money from me, and she said she'd pay me back, but she still hasn't. She hasn't returned my phone calls. All I have is text messages of her promising to pay me back. What are my rights?
Oh boy. Okay. So that's a typical breach of contract case, that you're lending money to your friend. They're promising to pay you back, either with or without interest. It doesn't sound like there's anything in writing between the two other than the text messages. If the text messages memorialize the agreement between the two parties, that can potentially be considered a written agreement. If the text messages came after the fact, it's just a text message saying, hey, you owe me the money, give me my money. That's not going to be considered a written contract, so it's going to be an oral contract. So with an oral contract, if you don't bring an action in court within 2 years of the breach, you waive your rights to bring a lawsuit. If it's a written agreement, then it's 4 years. And the next question is 2 years or 4 years from what date? And it's from the date of the breach, and that's where it gets a little bit complicated, and that's why we earn our money, because there's a lot of case law defining what that is.
I see. So if it's in writing, you have more time to bring this case.
Correct. So typically, an agreement doesn't have to be in writing to be valid. There are certain types of cases that it has to be in writing, like real estate types of cases, certain real estate cases. But generally, it doesn't have to be in writing, but it's always better to get something in writing, so there's no question about when the money is due, how much is it, whether there's interest, there's not, simple interest, compound interest. All these issues are things that go into a contract.
I see. And if it's an oral agreement, what's the evidence there? Is it word versus word, or how does that work?
So it can be my word against yours. It can be a canceled check, receipt. It can be a witness. It can be text messages saying, hey, just confirming that I gave you $500 yesterday and you're going to pay me back in 2 years. Something like that. So different things.
Gotcha. So it's good practice to put it in writing just to protect yourself.
Absolutely.
Okay. Fair enough.
Absolutely.
Well, Rod, I really appreciate you coming on today.
My pleasure.
I learn a lot every time I talk to you. So, ladies and gentlemen, hang tight and stay tuned for next time. Do us one favor, write down your legal questions, and Rod and I will answer them. Cheers.